Hearing in the matter of Galen and Stella Vick versus Reverse Logistics Trends Incorporated, Anthony Ciarata, I'm sure I mispronounced that, Reverse It Sales and Consulting, Reverse Logistics Association, and National Retail Federation. Case number 24CV002057. If I could get announcements for everybody, starting with counsel for the plaintiff.
Good morning, Your Honor. I'm John Strauss. I'm representing Gayla and Stella Vick.
Okay, thank you. And for the defendants?
Your Honor, this is Ramsey Knowles Gallant Timmons. I'll be doing the talking. I'm joined by my colleagues Karen Bain and Jordan Calto.
Okay, welcome. And then, of course, one of the issues so this case is on for a number of reasons. The most direct reason is that Reverse Logistics, let's see if I can keep these names straight when I was doing my homework last night. So RLT filed a motion to dismiss, and the National Federation, Retail Federation also filed a motion to dismiss. My understanding, Mr. Knowles, is you represent both of those entities, correct?
Yes, Your Honor.
Okay. And Mr. Strauss, you filed a response on behalf of both of those. And then there is also the associated issue of the fact that Ciarata, RIS, and RLA still have not been served. And as a result of that, my court procedure was to advise the parties we were going to dismiss if service had not occurred, and then we dismissed those parties. And now I am aware that there's been a motion to set aside the order dismissing less than all the parties. And I think I saw just recently a response was filed. Was that filed by you, Mr. Knowles? I have not seen it.
Yes, Your Honor. We just filed a short 1 or 2 page response, just in case. I know you like to read up on things before the hearing sometimes, so we wanted to let you know.
Well, and that was the only one I hadn't had a chance to read because I just became aware of its existence this morning at about 8 o'clock.
We can run through it.
But I do want to address that briefly. Mr. Strauss, before we get into the meat of the motion to dismiss, although given that those parties are not present, I don't know that it's dispositive of the outcome of anything today. But I do think that we should go ahead and address that issue. Mr. Strauss?
Well, Judge, I have had a chance to take a look at the response that Mr. Knowles filed. And basically, his response was that my request to set aside the order was actually, even though it was a few weeks after the order was entered, was outside the term of court. So I do agree that he's technically correct, that the court would then lack the authority to set aside its previous order that was entered in the previous term of court. Now, I'm not familiar with the terms of court, but I'm assuming that he's correct on that. And so I agree that he's correct. An interesting thing was when I was preparing for this hearing, the language of the agreements that we'll be talking about actually provides that any party may be served by overnight delivery.
I was going to ask about that. It also provides that everybody agrees to waive jury trials, assuming that assuming that that would apply to the people, the entities that were parties to that agreement. So,
and so, obviously, if I'd have realized that previously, and I should have, then at least for at least one of the other parties, we wouldn't be having this discussion. But in light of what has been filed by Mr. Knowles, I don't think I have any choice but to file a separate action against those 3 individuals, and then hopefully get them either served or one way or the other, and then ask to join with this case, assuming it survives the motion to dismiss.
Okay. Okay. So, I think this is an example of there being a number of ways to skin a cat, Mr. Strauss. And so I think that probably is the route that we will go, because I need to take a look at Mr. Knowles's response, but that was a concern I had in terms of the timing of the motion to set aside, and it is, or any order that I would enter on it. So, excuse me. So with that, let's go ahead and address the motions to dismiss that RLT filed. I'm going to start, if it's okay with you, Mr. Knowles, and Mr. Strauss, I'm just going to tell you the homework I did and what I think I have an understanding of to save everybody time from telling me all about the background of this. So that also means tell me if I've gotten something wrong that is, important, please let me know. But as I understand it, Reverse It Sales, RIS, entered into an agreement to purchase Mr. and Mrs. Vick's shares in RLT. And part of that was a purchase and sale agreement and also a personal consulting agreement. And the compensation for the purchase of the company was a percentage of gross revenue per month. Compensation under the PICA was also a percentage of gross revenue per month. And then the allegation, I think I understand it, is that they formed a new entity called RLA, transferred the assets of RLT to RLA, although RLA maybe kept paying some amount, allegedly. And then Mr. Ciarata sold all the assets of RLA to the National Retail Federation. Is that right? Yeah, National Retail Federation in 23. And that's where things, I think there's sticking to the four corners of the complaint, although that I agree with whoever pointed it out, it includes the PICA and the PSA or the SPA, because they were both referenced and attached to the pleadings. So what we have now, as I understand it, is a breach of contract claim, a tortious interference claim, an unjust enrichment claim, which I think everybody seems to agree is an alternative claim in the event there's not a contract. Of course, there's attorney's fees and expenses. And then there's an amendment that I just saw recently to add what I would call a rescission claim. Essentially an expansion of that equitable relief that was sought previously. And I will note that RLT also filed a counterclaim alleging misrepresentation, breach of contract, and attorney's fees. That's what I think I know so far. I have read the PSA and the PICA, but certainly not in anywhere near as great a detail as the parties are familiar with it. And that's what I got. So what we're here today on is Mr. Knowles. I'll let you go ahead on behalf of do you want to argue them just together on behalf of both of your clients?
Yes, Your Honor. And I think I'm going to, just to give you a heads up, focus more on the NRF motion to dismiss, because I think that one's more clear cut. May I share my screen? First of all, you pretty much nailed the situation. Maybe I was projecting a little bit, but I have trouble with all the names too, so I prepared like a very
yes, thank you.
Crude. Didn't have time for trial graphics, but just an org chart just to give you a visual of what's going on here. You got the plaintiffs, the VICs. They used to own RLT, which is my abbreviation for Reverse Logistics Trends, which is one of the current defendants. They sold that in the stock purchase agreement, as you noted, for $120,000 payable as 0.5% monthly revenue to Reverse It Sales, one of the former defendants, and it still owns RLT. RLT, in turn, as you pointed out, entered into the consulting agreement with the VICs. The former defendant, Mr. Sciarata, and I also have trouble with that name, he is the owner of Reverse It Sales, and that's my abbreviation there that's Reverse It Sales and Consulting LLC, the former defendant. He also owns RLA Inc., which is my abbreviation for Reverse Logistics Association Inc., which is another former defendant. And then again, Reverse It Sales now owns RLT. RLT in 2023 entered into an asset purchase agreement, selling the assets of RLT, some assets or maybe all assets, to NRF, which is a current defendant. I put NRF in a block here because it is, I think everybody would acknowledge, it's a separate entity. It's not something that Mr. Sciarata formed. I know there's an allegation he transferred assets to RLA. That's not relevant to the motion to dismiss, I don't think, but just for the court's information, I don't think that's exactly what happened. The RLT transferred assets to NRF, just to give you some background. So, unless you have want to keep that up, Your Honor,
Nope, I'm good.
I'll cut it out.
Or as good as I'm going to get with the alphabet soup that is going on. So
yeah, these cases with the similar names. The plaintiff admits in paragraph 17 of the complaint that one of the defendants has paid almost $500,000 toward those purchase prices, in the form of monthly payments that are a percentage of the gross assets, and that continued up until the asset purchase last year, and essentially RLT has no assets anymore, and so no revenues coming in. So our position would be there's been no breach, because the agreement just says you pay a percentage of monthly revenue, and there is no monthly revenue. Admittedly, Your Honor, the reason I'm going to focus more on NRF is because I think that contract argument in the RLT motion to dismiss, I could see how you might say that's more of a summary judgment argument. NRF is not a party to the contracts, any of the contracts here. And the plaintiff has acknowledged in its response to the NRF motion to dismiss that the unjust enrichment count is not directed at NRF because, quote, the plaintiffs, at least at this stage, are unaware of any basis to claim NRF has been unjustly enriched. So I think that knocks out the unjust enrichment claim. And again, the breach of contract does not apply to NRF, leaving the tortious interference claim. As we said in our motion, first of all, there's been no breach, but more importantly, for the motion to dismiss stage, there's no facts in the complaint supporting the elements of tortious interference, that there was some improper action or wrongful conduct without privilege, or that the NRF was acting with malice and purposefully with the intent to injure the plaintiffs. The closest the complaint gets to that is saying that upon information and belief, NRF was aware of the purported contractual obligations between RLT and reverse sales to pay the plaintiffs. That's not enough to support the elements of tortious interference. The plaintiffs are essentially just casting a wide net, going fishing. They say, in the response brief, they don't address this at all and just say discovery is going to flesh out the scheme, which again is just not enough to support the allegations or the counts against NRF. Moving back to
even from a notice pleading perspective, right? Like, even if, it would appear to me that there's not really any dispute that RLT, that its assets were purchased by NRF, and that presumably NRF would have some knowledge of RLT and its obligations. Maybe that's an open question. And so I guess one question I have at a motion to dismiss standard, which we all know is a very, very low bar, right, to get over a motion to dismiss, generally speaking. Why isn't it enough to say that NRF has in some way failed to ensure the obligations of RLT? Well, why isn't that enough?
Well, first of all, the complaint doesn't say that. All the complaint says is NRF was aware of the purported contractual obligations of RLT and reverse sales to pay the plaintiffs. And the elements of tortious interference are, that there was a breach of the contract and that there was improper action or wrongful conduct without privilege by NRF, and that NRF acted purposely and with malice and intent to injure the plaintiffs. And so the complaint needs to say that. It doesn't even say that. So we haven't even gotten to the point of questioning whether it's alleging facts. To support those allegations, but it doesn't even say
as opposed to conclusions. Okay.
Yeah. It doesn't even make the conclusion, is what I'm saying. And our position is that it can't. There wouldn't be any good faith basis to say that about NRF. Now, if the plaintiffs uncover something in discovery that leads them to believe that NRF was acting with wrongful intent or to injure the plaintiffs, they can move to add NRF at that point. But they're kind of putting the cart before the horse and casting this wide net and saying, look, we're going to fish around in discovery to see if NRF, induced the breach of the contract in any way or, intended to harm the plaintiffs. When really this is just at most a breach of contract action against the actual parties to the contract. And admittedly, NRF is a complete stranger to this contract or the entire relationship. The contracts were back in 2016 between Reverse It, RLT, Reverse It Sales, and the plaintiffs. 7 years later, one of RLT sold assets to this completely unrelated entity, NRF, and there's no allegation that NRF tortiously interfered with those contractual obligations. It's just not alleged in the complaint. Feel like you might have a question on that, Your Honor.
Sir, no, I'm just
go ahead.
listening.
Okay, go ahead and move on. So again, unjust enrichment, admittedly, in the response brief doesn't apply to NRF. We haven't briefed it, but I looked at the amended complaint, and I think that is making that new count applicable to NRF. That count is for equitable relief. I'll note that none of the allegations that support equitable relief are in there, particularly, the allegation that money can't make the plaintiffs whole, that, is required for any equitable relief or equitable count. And in addition, the basis for the rescinding the contract, to the extent, it's not an equitable count, even though it's called that, or the plaintiffs didn't have to actually allege the elements of equitable relief. That's, the grounds for the rescission are that the agreements were vague, or it's like in the alternative, like if plaintiffs are right and they didn't have to pay because there's no revenue, then the agreements are vague, and that's a reason to rescind. But that's not a reason to rescind a contract. If the agreements are vague, which they're not, we're just saying if they do say you don't have to pay if there's no revenue. If they are vague, then the court would just go in and look at extrinsic evidence to prove the intent of the parties. That's the remedy for that, not an equitable count for rescission. So the two counts that are potentially applicable to NRF, tortious interference and this new claim for equitable relief, just don't lay out the elements for those causes of action against NRF.
Okay. And so one remedy is to order an amended complaint. Why would that not be a more appropriate remedy rather than a dismissal of NRF?
Well, Your Honor, like I said, we are not aware of any facts, and I presume the plaintiffs are not either, because they didn't put it in either of their complaint or amended complaints that would support these allegations. I think if they did put it in there, it would just be a rote recitation of the elements, because there aren't any facts to support. Well, first of all, the new claim for equitable relief says return money. This is all about money. So I don't think they can say that, money can't make them whole. And then with tortious interference, in the response brief to the motion to dismiss, the plaintiffs admit they don't really have any information that NRF was unjustly enriched. I don't think they have any information that NRF tortiously interfered with the contract. I think it would not be a good faith allegation if they make that. So I think the appropriate remedy is to dismiss. Frankly, Your Honor, I think what should happen here is I think the VIX, if anything, should just make a breach of contract allegation against RLT, which is a party, and then the former party Reverse It Sales, who was a party to the SPA. This is a breach of contract claim that the plaintiffs are trying to spin up into a global conspiracy theory and loop in these other parties that aren't that weren't privy to the contracts, just as leverage, so that, NRF will put pressure or something, I guess, on the contract parties. But, NRF and Mr. Sciarota really don't have anything to do with these, the SPA and the consulting agreement. They're not parties to it. And finally, Your Honor, I'll just move back to RLT. At a minimum, I think the motion to dismiss, the RLT motion to dismiss should be granted in part. There's no dispute here that the contracts are valid. I think we admitted it in the answer and counterclaim. The SPA and consulting agreement, everybody agrees they're enforceable. And in that situation, unjust enrichment and the resulting trust or constructive trust, can't stand as a matter of law.
Right, but that's generally something that the court is deciding at the summary judgment stage or even at the pretrial order stage. At some point a party's got to pick a horse and ride it, right? But at this early stage, particularly with the amended complaint edition, arguing that if in fact there is no provision that prevents the owner of RLT from selling away its assets and therefore depriving the VIX of the benefit of the bargain that they believe they struck, right? Then that was a fundamentally unfair contract that should in some way be undone. And then you're right back to your equitable remedies. And so I don't disagree. In fact, I think Mr. Strauss's response brief says the same thing. Everybody acknowledges that equitable relief in this context, unjust enrichment, et cetera, is an alternative to a breach of contract claim. And it appears that there are two contracts that everybody agrees were valid and enforceable. But I think the issue of whether an unjust enrichment claim can no longer exist is not right now. It might be later. I'm just not sure if that would procedurally be appropriate, or I guess your position would be, well, if the contracts fall apart, he could always, amend his complaint and seek add a claim for unjust enrichment.
Sure. Yeah. And if the claim against RLT for breach of contract is going to continue anyway, then it might be best to address unjust enrichment on summary judgment, once we've had discovery and made sure that the contracts are valid. But our position would be, it's admitted, it's kind of the law of the case, I guess you could say, since the plaintiffs alleged that they're valid and RLT admitted it's valid. So I think you could dismiss it at this stage. But if you're going to let the breach of contract claim against RLT continue, our argument there is there's no revenue, but I don't know that we can pin that into the pleadings. So that may be a summary judgment issue anyway. But again, so I would again focus on NRF and just the lack of any allegations supporting the two claims that are potentially applicable to them, and the inability to make those allegations without exceeding the duty to make allegations in good faith.
Understood. Anything else, Mr. Knowles?
That sounds like we're all good on the motion to set aside. Everybody's in agreement on that, or did you have any questions for us on that, or want to come back to it?
No, I don't think so. Okay. Mr. Strauss.
Okay, Your Honor, I want to start a little bit more globally than just NRF. Of course, as Your Honor noted, I appreciate all the homework that you did getting ready for this. We've got the stock agreement and the consulting agreement. Our position is that both of those need to be considered together. They're both referenced as part of the stock purchase agreement. There's a paragraph immediately after the consideration in the stock purchase agreement, which is the purchase price is in paragraph 3. And then in paragraph 4, it references the consulting agreement that is part of this global package. So it's our position that both of those need to be considered together. But let's assume for the sake of argument that they're not considered together. The bottom line is the $120,000 for the purchase price of the stock has not been paid. that's a breach. And we've alleged that that's a breach. We also have alleged that not only is it a breach, but that National Retail Federation is aware of that breach. And so under those circumstances, there's no way the National Retail Federation can be considered a bona fide purchaser in this action. Now let's get to the other issue that's a pretty big issue about this stock purchase agreement. Paragraph 16 of the agreement says, no party to this agreement may assign any of its rights or obligations hereunder without the prior written consent of the other parties hereto, which consent may be withheld in the sole discretion of the party from whom consent is sought. My clients have not provided any consent for the stock of RLT to be sold. Now, we didn't know, there's been no discovery. It's been stayed, so we didn't know exactly what NRF purchased, but Mr. Knowles just indicated that NRF purchased the assets of RLT. Well, we didn't consent to that. And we have alleged that NRF is aware of all of these terms of these agreements. And if they're aware that there's an anti-assignment provision and they went ahead and bought the stock anyway, then yes, they've got problems. Now, and if you take the arguments that the defendants are making to their furthest extent, there's no purchase price. They can sell that. They could have sold, if you're following their arguments, they never had to pay the VIX a dime. The contract was done in July of 2016. They could have sold the company in August of 2016 before any revenue was received, and then they'd have no obligations whatsoever. And that just can't be. And in fact, if there is no purchase price and there is no definite obligation on the part of the buyers in this transaction, then that contract is unenforceable. If you can't have a contract to purchase something without a purchase price. And so if that's the position that they're taking, then there is no contract of either one of them. And so that's where our alternative claim comes from. You either need to pay what you agreed to pay, or if there's no obligation or certain amount you're supposed to pay, then you're just renting this company and there is no purchase of our stock and we need it back. And the allegation is that NRF was aware of all this and that they went ahead and did it anyway. And as we've alleged in the amendment, not only did they do that and get the assets, in the last few months, they moved $475,000 out of RLT's account. And so how can you be a bona fide purchaser for value if you're aware that what you're purchasing hasn't been paid for? You're basically purchasing something out of trust under those circumstances. Some other interesting points that I would make is that, and again, we haven't seen any of the agreements at this stage, but typically when you are purchasing the assets, you're also purchasing the obligations. And the term of the personal consulting agreement, under its terms, it doesn't terminate upon sale of the company. It shall only terminate when the maximum consulting fee has been paid. This is paragraph 5, which is $1,080,000, or the death of the last surviving consultant. So that agreement is still in effect. And again, we don't know exactly what the terms of the transfers were between RLT and NRF, but you can't just get the assets and not the obligations too.
But so, I mean, I think as I understand Mr. Strauss, as I understand Mr. Knowles' basic argument regarding NRF is that what you are saying, what you're outlining, what you're trying to allege in your complaint against NRF is supposition not based on factual allegations at this point, because you don't have the factual allegations, as you have said, right? You don't know what that agreement looked like yet. And I think by logical extension of Mr. Knowles's argument that there's no reason that you couldn't have sued RLT for breaching its agreements and all the associated entities, right? For breaching the PICA or the SPA. But there's nothing, according to him, in your complaint that says NRF actually committed a wrong in what its actions are. And so why not wait, do the discovery? Because you can still ask for all those documents from NRF and, and get that information either from RLT or NRF or both, even if NRF's not a party. Why not approach it that way? And then if you determine that NRF had information that would mean that their purchase was improper or with intent to injure, etc. I mean, because those are the, elements of a cause of action for tortious interference.
Your Honor, I think on the face of our complaint, when we allege that NRF purchased this company with the understanding that this company, first of all, couldn't transfer its assets anyway without my client's consent. And secondly, that my clients hadn't been paid, then that sets a valid claim. And not only that, as we've alleged in the amendment, you take the next step, they're taking our company's assets away. They're moving $475,000 of our company's assets that have been wrongfully transferred without our consent. And yeah, at this stage, at a motion to dismiss, as you'd indicated, it's an extremely low bar to get over that. But I would respectfully contend that that is sufficient to allow us to conduct discovery. If I don't think, and after seeing all this, that if nothing else, we've got a claim for them to return our $475,000. Because RLT is going to need that money to compensate us.
Okay. Give me for just a moment. I'm looking at the allegations of the complaint. Okay. Mr. Strauss, do you have anything else? Now, I was going back to look at the amendment for a moment and then also at the original complaint as well. Do you have anything else you want to add? So generally what I do is the person who made the motion gets the last word. So I'm going to allow Mr. Knowles to rebut if he wishes to. But before I do that, Mr. Strauss, do you have anything else that you would like to add?
No, Your Honor.
Okay. Hang on just one moment for me, Mr. Knowles, before you add anything. So I do have a question, Mr. Strauss, when you just said a moment ago that, part of your alternative count 5, your amendment, right, is so assuming all these contracts are valid for a moment, RLT doesn't belong to the VIX currently. But assuming that is correct, right? Am I correct in understanding that your argument is, but if there's no contract because there was no purchase price or no meeting of the minds or whatever reason, then ownership of RLT fundamentally never transferred away from the VIX. Is that roughly accurate?
Yes, Your Honor, that is roughly accurate. And that at that point in time, um, yeah, then we do have to deal with what is the remedy for all the parties involved under those circumstances, and that's where NRF needs to be involved because they've got the assets of RLT. And if the contracts, though, on the flip side are enforceable, then NRF is aware that RLT has been transferred in violation of the contract. And the agreement with respect to NRF would still have to be undone.
Okay, I think, and this is very premature, but I think what I'm struggling with is in the absence of specific information that might imply wrongful behavior. I'm struggling with how we would attribute that type of knowledge or obligation to an arm's length good faith purchaser, which all evidence is that they were, depending on what they were told or not told. At least that's what I understand currently.
Well, Judge, this is a pretty small industry. Everybody knows everybody. If I'm not mistaken, Mr. Scarata was actually already doing some work for NRF. And I just cannot imagine that NRF, well, first of all, in this industry, NRF is going to know about my clients because my clients were basically movers and shakers in starting this whole industry. And they're going to know that in general that there's a transaction that involved my clients.
Right, but I think Mr. Knowles's point is just knowing that that contract existed isn't necessarily enough to attribute to them an obligation not to defeat the purpose of that underlying contract. That's all I'm trying to work through.
What I was going to get to is with that general knowledge, I cannot imagine that a company, I don't know what they pay, but I cannot imagine that a company is going to purchase RLT without looking at the agreements that RLT had with my clients and RIS had with my clients. And if they did look at those agreements, they would say, oh my goodness, we can't buy this company without the VIX consent. And so simply because I can't prove that they looked at this contract at this stage without doing any discovery, I don't think is a with all due respect is a valid basis to dismiss the complaint.
Okay. Thank you, Mr. Strauss. Mr. Knowles, would you like to have a brief rebuttal?
Yes. So, Your Honor, we're limited to what the complaint says, at a motion to dismiss stage, and what the motions and responses say. What the plaintiffs admit in their responses. Again, so the two remaining claims against NRF are this new equitable rescission claim that's filed yesterday. To the extent we need to, at this time orally, move to dismiss. I think if that wasn't already taken care of, but or to add that to our motion to dismiss. But the equitable elements just aren't there. It's an equitable claim, and it's asking for a rescission, and there's a vague contract is not a basis for rescission. Rescission has to be based on something like fraudulent inducement. So it's just not a valid cause of action under Georgia law. In addition to not meeting the elements of equitable relief, which pretty much leaves tortious interference. There's Mr. Strauss is thrown around a few concepts like bona fide purchaser, and I think kind of a successor liability theory, that maybe the defendant RLT is insolvent, and that eventually for RLT to pay, assets would have to come in from NRF. Those are all other theories of recovery, or remedies. The question on the table is whether NRF tortiously interfered with the contract. That's an intentional tort with punitive damages. It has elements that you're required to prove to establish that intentional tort. And, those include improper action and wrongful conduct without privilege, acting purposefully with malice, with the intent to injure the plaintiffs. That has not been alleged in the current complaint. And we don't think that the plaintiffs can allege that in good faith, because all they know is that, or, upon information and belief, that NRF was aware of the contractual obligations, which again is several steps removed from the elements of tortious interference. Like, just because NRF is aware of the contract doesn't mean NRF did a study of what the contract obligations are, whether RLT was in breach of those, whether the transaction was going to breach of those. Like, that would require several allegations just to get to the point of where you could support a tortious interference claim, and it's just not in the complaint. That's
One
all
question
I
I
have.
did want to clarify, Mr. Knowles, and I thought I heard you say at some point that NRF is not really a target of the unjust enrichment claim, but paragraph 34 of the complaint very clearly says defendant NRF has acquired tangible and intangible assets. And the reason I'm asking for that clarification, because perhaps I just misheard or misunderstood what someone had said. But at a minimum, if that is alleged, right, if NRF received the assets of RLT in a way that they were not entitled to receive, or, I mean, I guess I just want clarification of what do you think is NRF's role in the unjust enrichment, other than the fact that it's alternative to a breach of contract, but that wouldn't apply to NRF because NRF isn't a party to any of those contracts. As an alternative form of relief to the tortious interference claim.
Your Honor, I'm sorry, I have misplaced one of my, oh, wait, here it is. Your Honor, what I was referring to, may I share my screen?
Yes.
What I was referring to when I said that is
the response brief.
The response to the NRF motion to dismiss.
Okay.
Says on page 4, on the issue of unjust enrichment, plaintiffs acknowledge that this count of the complaint was not directed at NRF because plaintiffs, at least at this stage, are unaware of any basis to claim NRF was unjustly enriched.
Okay.
To the extent that that is still, applicable, I think that is, kind of an in judicio admission that takes that off the table. But that there's no allegation that, for unjust enrichment, you would have to allege that plaintiffs gave a benefit to NRF with the expectation that NRF was going to compensate them for that. And, we're talking about 7 years of time between when plaintiffs provided something and when NRF received something. There was no expectation of payment from an NRF. So that was our substantive argument, but it appears that plaintiffs conceded that that's not applicable this time.
Okay. Okay. So as I said, the reason I did my homework on this is because I find that when there are multiple corporate entities and there are things going back and forth, it's important for me to try and make sure I'm focused on what is the nature of the relief sought and at which entity and what are the roles of those individuals. It's unfortunate that the other defendants are not present. And so perhaps we'll gain some insight if and when that ever occurs. But here's what it boils down to. So I've already said that the motion to set aside the order dismissing less than all the parties, I'm going to deny that motion because I think that I don't have the authority to set aside that order based on when it was entered. But I fully expect that, according to Mr. Strauss, that what I'll end up seeing is another new complaint relative to those individuals. And then I guess we can have a conversation later about consolidation. Now, as to the motions to dismiss, Mr. Knowles, I think that you were wise to focus your efforts on the National Retail Federation rather than RLT, because I think that the nature of RLT's objections are such that the court, even though the complaints includes, or the pleadings, I should say, include the stock purchase agreement and the consulting agreement, the nature of the objections raised in the motion to dismiss really are factual issues about whether there can be proof of those elements. And so for that reason, I don't think there's a basis to dismiss the claims against Reverse Logistics Trends. Now, I might end up, when we get to the summary judgment stage, there may be a whole lot of cleanup that we have to do in terms of, do we have a contract? And if we do, are we getting rid of these equitable claims? There may be theories that ultimately don't succeed in terms of trying to proceed with RLT. But for now, I think that the plaintiffs have survived the low bar that is necessary to allege actionable claims against Reverse Logistics Trends Incorporated. I'm not sure the same can be said for National Retail Federation at this time. I understand your concerns, Mr. Strauss, but I think that I've looked at the complaint and reviewed everywhere that NRF is named, and including the amendment. And while I understand the theory, I think that you have to allege facts that would demonstrate a basis. And you, I think in good faith, have acknowledged that you believe that you will be able to demonstrate that, but you don't have any evidence to prove it at this point. And it's not just that you don't have evidence, but it's because you lack evidence, in good faith, you have not made spurious allegations in your complaint. You ultimately may be able to make such allegations in a complaint, but I don't think that what is alleged here sufficiently demonstrates that there's a cause of action against National Retail Federation. So what I'm going to do is deny the motion to dismiss Reverse Logistics Trends, and I'm going to grant the motion to dismiss National Retail Federation. That is obviously without prejudice, to the extent that anyone wants to add them back as a party, if there's a better whatever, then those are all tactics that y'all can undertake. I assume that National Retail Federation understands that it will be a target of discovery in this matter, even if it's not a party. And once you have discovery, perhaps you can, Mr. Strauss, develop whatever theory it is you are trying to pursue relative to National Retail Federation. Beyond that, Mr. Knowles, if you could please provide me with a proposed order denying the motion to set aside and a proposed order denying the motion to dismiss. Mr. Strauss, if you could please provide me with a proposed order denying the motion to dismiss Reverse Logistics Trends in Word format. I will usually edit them, and I may even put them all together in one order just so that we have one document. But I have found much easier to get proposed orders from the lawyers. Sometimes I will say this because sometimes I find that I have to. I probably don't with y'all, but this is not an opportunity to re-argue your position. And it's not an opportunity to put a whole bunch of words in my mouth that I'm not actually saying in my ruling to you verbally. I just need something that will give everyone an appropriate resolution of those motions so that they can take whatever action they believe is appropriate next steps for those actions or for those rulings. Anything else, Mr. Strauss? Anything else, Mr. Knowles?
No, Your Honor, nothing for the defendants.
Okay. Realistically, I know it's Friday. Can y'all have me those proposed orders by next Friday at the latest?
Yes, ma'am.
Yes, Your Honor.
Okay, excellent. Well, I will look for them. As soon as I have them, I will get them on file and we will go from there. Anything else?